what could be the alternative, so to speak. And so I do have the experts with me today on the deck, and I'm joined by Mr. James Magere. He is an amazing person. He is the President, Mediation Institute of East Africa. Thank you so much for making time.
Welcome.
All right, and also I'm joined by Mr. Vincent Emmy Mugabo. He is the Registrar Supreme Court right here at the judiciary here in Uganda. Welcome so much.
Thank you. Good morning, viewers.
Good morning. All right, I think I'll start with you, Mr. Emmy, Vincent. Let's talk about the issue of case backlog in Uganda before I bring in the mediation expert, of course, for him to give us what alternatives we have. How bad is the burden?
The burden of case backlog is very big. We are talking of close to 200,000 cases in our court system, which cannot be resolved in time. For many reasons. One is because of the processes. Two is because of the manpower. Three is lack of our awareness of how to go about these matters by the litigants. So what we do is we give them an opportunity, at the earliest opportunity, to resolve these matters that come to us through mediation as a first door that they face when they come to court. The reasons behind that support is it is time effective, it reduces on the cost, it helps the parties to maintain their relationship, because even after court, you need to maintain this relationship.
Right.
When a decision is made by the court, unfortunately, it is a winner and a loser. But when the parties sit together, there is a mutual understanding that the parties get, and that mutual understanding helps us to have a win-win position. So that's why we encourage as many of the people that come to court to give an avenue to mediate their matters.
Right, and I know there are issues that come to court and you tell them, is it possible for you to sort it out of court within yourselves? But what's the uptake like? Are Ugandans open to this alternative, measures of, sorting their issues out?
Yes, we have, over the years, we have a community that is growing to appreciate mediation, to appreciate the advantages. They have seen successful communities resolving their disputes, so that helps us to move forward. But then, of course, we still need to keep sensitizing. Not everyone keeps coming to court. At a time X that you need the services of the court, currently we have issues of corruption and all this.
Right.
If we are able to resolve our matters, then we do not be facing these concerns of corruption. So that's why we keep encouraging as even communities, before you come to court, you can engage and resolve these disputes. But where you have also failed to resolve them, you can still engage at the court level. We use court-annexed mediation and help the parties resolve these disputes.
All right, okay. So, Mr. Magere, this big term, mediation, I'm sure we are all, aware of it. We somewhat have an idea of what it means, but ultimately, coming from the books of law, what is mediation?
Well, mediation is assisted negotiation. People have been negotiating. They have reached where they can't communicate anymore. A third party comes into a system to open lines of communication and be able to explore their settlement possibilities in a safe environment. So this third party has to be neutral. It does not have any interest in the case. It doesn't lord over them. It's a self-determination process where parties are assisted to make their own decisions. And when they make their decisions, they are easy to implement.
Right.
Yeah.
You said that we have to have someone who is, non-biased, doesn't side with any of the two sides,
Yeah.
But who then is qualified to be a mediator?
Well, mediation is a science. You must be trained. We train you in communication skills, negotiation skills, emotional intelligence, and the processes that are involved. That's why not anybody else can mediate unless you have got some specific training. It's just like the training you have in arbitration. You can be arbitrate and issue directions. In mediation, it's a self-determinative process where parties are given the opportunity to make their own decisions, and I think it's a very popular process.
Right.
Yeah.
You know, Mr. Vincent, we had this conversation before we went on air, and you said that even the judiciary is deliberate about training quite a number of people to, you know, own the skills of mediation, just to ensure that we reduce the number of people coming to, you know, the litigation process to courts, and so to speak. So when you go on ground, of course, with a keen focus of wanting to train people in mediation, who exactly do you look out for?
Well, thank you for that concern. When we started in 2014 rolling out, we were looking at officers of government in the jail sector. But we realized that pool was not sufficient for all of us. What we did now, we went to the communities. There we would pick the cultural leaders, the political leaders, the civic leaders, and of course the judicial officers, the lawyers who are in practice, and therefore we got a very big pool. We know some communities who believe in elders, we know that there are communities who believe in their religious leaders, the Qadis, the priests, the sheikhs, and we brought all those on board. We gave them skills. First, they could help us resolve these matters at their community level. But even where they have not been able to resolve them at the community level, when the matters come to court, we can refer them back to these very people that we have trained to assist us talk to these people. So yes, we have a very big pool of people that we have trained in mediation skills.
All right, in mediation skills.
Yes.
Mr. Magerere, what's the process of mediation like? Because many will say that we were, you know, at some point in time A maybe, we got into some conflict, and some people tried to, you know, make us talk and, you know, find some reasonable ground to sort our issues, but that never happened. And many are saying that, you know what, maybe we didn't appreciate this much because we didn't understand what mediation is and what the process ultimately ought to look like. So what's the process of mediation, ideally, an effective mediation process?
Well, I think I need to give you a difference, first of all, of the ADR processes, because people confuse that a lot. In the alternative dispute resolution process, we start with negotiation, where parties have back and forth communication. And we can negotiate in two ways, through confrontation or through collaboration. Then after that, once you fail in mediation, you go into once you fail in negotiation, you go into mediation. Mediation is where a third party comes in now to assist you to negotiate, open lines of communication. From there can be something like conciliation. And people confuse mediation a lot with conciliation.
Yes.
Conciliation is where a third party comes in to propose a solution and then drive the parties to that solution through the process of shadow diplomacy. We have other processes like neutral evaluation, where a third party comes in who has legal knowledge to give you information of, to give you the likely outcome of a case if it went to court. We have things like Mediap, where you start with mediation, you end up with arbitration. AppMed, where you start with arbitration, you end up with the mediation. We have things like adjudication, which is resolution of disputes in construction disputes. We have things like arbitration, which is a quasi-judicial process, where a third party assists parties to make a decision. Then we have litigation, which is not for everybody.
Yes.
Now let me tell you about the mediation process. In the mediation process, first of all, what people do is that you bring people on the table. First of all, having educated them about what the process is so that you don't surprise them. You introduce yourself, they introduce themselves, you take them through a checklist of what is involved in the process, where they have authority to resolve the disputes, because there's no need why you should have people on the table who don't have authority to resolve.
Correct.
You tell them about your role, issues about confidentiality, because that process, whatever you discuss within it, cannot be disclosed anywhere. The voluntariness of the process, because anybody who is upset can walk away from the process. Once you've gone through that, give each person an opportunity of presenting their case. Isolate issues, help them to generate options that can raise those issues, exchange offers, and come up with an agreement. So straightforward, and people come up with creative solutions to disputes. And like what the court does, the court will give you a decision. You have to live with it whether you like it or not. But in mediation, parties have the authority, the power to make their own decisions, which they can live with. So it's a more appropriate process, more than the other processes that I've told you, and it's the most well-used process all over the world.
All over the world.
Yes.
You know, Mr. Vincent, many would argue that mediation only works for light cases and not the heavy cases. Is that right?
No, it is not right. We have seen it work in all the matters that we are able. When we are rolling out to go to the other divisions. You know, it started with the commercial court. And then people thought, you know, these people are dealing with money issues and therefore they can easily resolve. How is it going to be handled in the land? How is it going to be handled in the civil? And then we sent there some mediators. One of the cases I remember very well, they gave me a matter involving death in a hospital and said, mediate this one, and this is a civil matter. We sat into that matter and mediated it successfully and resolved. And then everyone's eyes were open, said, oh, even these matters can be resolved. We have had successful mediation, even in election petitions, where, you know, there is a lot of anger. I have lost my constituency. There is no way you can take this constituency, and I wait for 5 years. And we have people sit them down, negotiate the settlement, and they resolve their matter. So we have seen it work in all these other cases, whether complex, whether small, whether big. As long as the parties buy into it, have an opportunity to understand what it is all about, they are able to resolve these disputes at the earliest opportunity.
Is this exclusive of, you know, cases or, you know, injustices that are against the law of the land, especially when it comes to matters to do, for example, crime? You know, does this, you know, exclude that, or it's all inclusive?
For mediation, we normally do it for civil matters, civil, commercial, land, family disputes. We are very good at that. When it comes to criminal matters, we also have another form of mediation, which we call the plea bargaining. Now, here in the criminal matter, somebody has to own up. Instead of waiting for your trial for 5, 6 years, you're on remand or you're on bail, you wait, you don't know your fate. You own up you are wrong. You say sorry to the community that you have wronged. And then you ask for a lenient sentence, a lenient penalty. So that is still a negotiation settlement, but it is called plea bargaining. It is the actual thing is that it is a mediation.
Yes.
You sit with your people and say, yes, I wronged you, I wronged this community, this is what I did was wrong, but I'm praying for lenience. Then you reach an agreement, which now agreement is taken to the court, to the judicial officer, to determine the appropriate sentence to give you. So yes, it is another form of mediation, but we call it plea bargaining. It is an ADR mechanism in the criminal area.
All right, okay. Mr. Magerere, post-mediation, because even when it comes to, you know, cases that have gone through the legal process, you know, the litigation process and stuff like that, it gets to a point, you're all human beings. It gets to a point whereby human beings will not follow what the court said. So when it comes to mediation, where does the power lie in the post-mediation process to ensure that both parties actually abide by what was agreed upon?
Well, I think usually when people have made their own decision without being compelled or taken through duress, these people tend to respect those decisions, because you're not forced to sign a mediation agreement. That's the first thing. You do it out of your own volition. Now, in countries like in our country, you are allowed, once people have gone through mediation, you are allowed to present the agreement to court, and it can be adopted as a court order or a judgment. And there's also a provision in our practice directions that court agreements that emanate from mediation are not appealable. They can't be set aside by any court of law. I don't know if that is available here. Then I think we have not seen many cases where people renege or go against the agreement that they have signed, because the process is free, it's voluntary, it's confidential. People arrive at decisions that are creative, that are mutually acceptable to both. So you find that the degree of going against those agreements are very low. They are rare, in fact.
They're rare.
They're very rare.
But what happens when it happens?
When it happens, if you have already converted into a court judgment, you can execute as any court judgment. Remember, the agreement that emanates from a mediation session is a contract enforceable by law. It's no longer private. Now, that one, you can either follow it through the law of contract or go through a summary judgment in court. But remember, it was made not under any duress. It was made out of people's free will.
Right.
Yeah. They respect it most of the time.
Right.
Yeah.
Mr. Vincent, we know that matters to do with, you know, people finding justice is a huge issue across the country. So as you've mentioned, you started this journey in 2014, just making sure that you train as many people as possible in mediation. So how many regions have you been able to make an impact on?
Fortunately, we have moved the whole of this Uganda. There are very few areas that we have not concentrated on. In fact, maybe only two: the Greater Masaka region and the Masindi region. But otherwise, we have been to Arua, to Gulu, Lira, Soroti, Mbale, Jinja, and all the western part of the country. We have people there who have skills. We have people who have knowledge. They may not be practicing, but when they see an issue in a community, they are able to say, this is how you can resolve it. This is what, even, you know, some of these people need to be talked to. They just want a listening ear. We have people in the market stalls there, they get conflict. Rubbish has fallen here, this has happened, water is coming to this area. You don't need to come to court. You can sit down and say, how do we resolve this? Do you put up a tunnel? Do you do this? How do you have a garbage collector? And they are helping us to resolve these issues at the community level. So we have quite a number, but even in the places where we have not trained and sensitized, we even still have some staff there. Like in Hoima, we have not done a lot of training, but we have a reverend who is doing very well. This is a religious leader, has resolved almost 90%, and even he is very successful in land matters, because people thought maybe land matters. His approach is different. His approach is different. As a priest, he first prays for them, talks about reconciliation, reads the Bible to them, and then they will understand a different perspective, and then from there they go now to discuss what is at stake in their dispute. And over 90% of the matters he has handled in Hoima area have all been settled.
Okay, interesting. You know, the judiciary earlier this year did an amazing thing. You are now employing the technology to be able to sort out issues and to be more effective, especially when you were hearing the case of the Chad and the East Member of Parliament. That was quite amazing. But on this other side, someone would say that if then you're making great strides in, you know, training many people in the different regions of Uganda in mediation, then why are we still having the issue of case backlog? What is the ultimate solution to sort out this issue?
One is that we have talked about the manpower issue.
Yes.
We have gazetted courts which do not have judicial officers. Where we have judicial officers, they are overwhelmed. Now, there are also communities who are litigating on every issue that comes up. We are also human beings. We have 365 days in a year. We can't handle everything.
Right.
If we went to the commercial court, for instance, on average, every year it registers over 2,000 matters. Every year. Now, those 2,000 matters cannot be heard in that very year. But two is that even where you have judicial officers, they cannot deal with all those cases at a go. So what are we saying? Let's adopt these other practices. Let's go for ADR to help us reduce on the number of cases. There are matters which may not be amenable to mediation, especially where there is fraud and all this. People may not easily sit on a table and discuss a fraud. So those are the issues that we have. As long as we can sensitize the communities not to file even these cases, then we would reduce on what we have and would be able to, but also we appeal to government to recruit more officers to help us. The population is growing. At High Court we are supposed to have, of the 82 judges we are supposed to have, we only have about 49 active judicial officers. To work in a country of over 40 million people, it is impossible that we can deliver justice at that level. We are supposed to have over 100 chief magistrates. Chief magistrates handle disputes up to 50 million. We have like 38. Now, how do you expect a chief magistrate is having a region? For instance, if you go to Fort Potro, a chief magistrate is having Fort Potro, Kabarole district, is having Wundubujo, is having Kamwenge, is having Kienjojo. I mean, how do you expect him or her to run all over and hear these matters in a timely manner
So
if we don't approach.
By and large, the ultimate solution would be to increase the manpower.
Yes, increase of the manpower, but also adoption of all these other alternative means to resolve the disputes.
All right, okay. Mr. Magerere, you are an ADR expert.
Yes.
And you help not just Kenya, Uganda, I mean,
I train all over the world.
You train all over the world.
Yes.
And someone would say that, hey, okay, fine, mediation could be an option, but even with the normal process, the normal litigation process, many have been taken advantage of. Many have actually accused lawyers and legal officers of corruption and trying to say, okay, give me kitu kidogo so I can push your case. So what exactly happens with mediation?
Let me tell you, and I want to assure the public, that the only and the most credible process is mediation. Why? Because a mediator doesn't make decisions. So it doesn't matter whether you give them money or a bribe or anything, they won't help you. What mediators are coming to do is to assist the parties to do what? To agree. And it's a voluntary process. If you feel that a mediator has got some conflict of interest, you are free to walk away. And like the case where you are confined to a place, you must stay somewhere and have somebody make a decision on your behalf.
Right.
So the voluntariness of the process, the confidentiality of the process, self-determinative nature of the process makes mediation a very credible process. In fact, if you are afraid of any other processes, come to mediation because you can walk away
yes.
anytime you want. The process is voluntary. You have authority to make a decision on your behalf.
Is there any document that governs the, pretty much the degree of engagement? When it comes to law, if I have an issue and I approach a lawyer, we always, have a contract signed, some, laying some foundation on how we're going to engage.
Yes.
So does the same happen in mediation between the mediator and these two parties?
There's what initially when you start mediating, there's what we call a mediation agreement. There are 4 things that you establish before you mediate.
Okay.
Personal credibility, first of all. Procedural credibility, institutional credibility, and the substantive credibility. Now, there is something about what we call a psychological contract. The both parties must believe that they have a commitment. You have a commitment to assist them resolve the disputes. But you are not like an arbitrator who can issue directions. That commitment is what puts you on the table. And once you start any mediation agreement, you are supposed to sign that agreement at first. First of all, the agreement deals with the element of confidentiality and the consequences of breach of confidentiality. It also deals with the issue about your fees. Then it also deals about that commitment that the mediator has got power to terminate the mediation without assigning any reasons.
Okay.
That is what gives you the impetus to continue the mediation process. And we encourage most people that before you start any mediation, let that agreement be signed that binds the 3 of you.
All right.
But that doesn't mean that you have any power, to make a decision.
All right.
Yours is to assist the parties make a decision. If they come up with an agreement that does not please you as a mediator, it is their dispute.
Okay.
You agree with it as a person.
Mr. Vincent, are mediators compensated?
Yes. We have a challenge in Uganda of funding for mediators, and we have been discussing with government on how best to compensate them for their time. We appreciate the time they give us. We appreciate the costs that are involved. They have to travel to these courts. They have to call the parties. They have to follow up. Sometimes you need to make some calls. You have to send some emails. There are several activities that are involved. So they are supposed to be facilitated. When we started the rollout, we had a project supported by the Austrian government. And they did support and would compensate the people for the time they were putting in. When the government finally took it over, they also provided funding to support the activities to move on. But sometimes when there are financial constraints, we get a hiccup where we are not able to facilitate them, but we continue to engage the government. We believe even this financial year that has started, we are going to receive some funding to assist us compensate the court-annexed mediators who are giving us this tremendous service.
All right. And before I go to Mr. Magerere, how should the public, or what's the mechanism of the public, identifying these trained mediators? Where can they find them?
Now, in every community we have a list. What happens when we train you? It's not necessarily that you are going to be a mediator. When we train you, there are those who express interest in being accredited as a mediator. So we provide you an accreditation service where we give you an appointment letter subject to renewal every year. So that person becomes a court-accredited mediator. And that information is provided at all the courts in Uganda for that community.
Okay.
So you can pick from those. But also, in addition to the court-accredited mediators, the parties are at liberty to appoint any person with relevant experience in that field, whether trained or not. But the other probable mediators provided under our rules are a judge, a registrar, a magistrate. Those have all been trained and are allowed to do mediation. So we have quite a number of a pool that somebody can pick. But even where you are not able to pick or to know who is available for mediation, when you go to court, in charge of that station will allocate you a mediator to help you through the process.
All right. Okay. So it's quite clear.
Yes, it's quite clear.
All right. Mr. Magerere, so I have an issue with, for example, maybe David Rukasi or Mr. Vincent, and we come to you as a mediator. Is it in your place to tell us what you will maybe rate us, what your rate card is, or the law says that a mediator ought to first help us, and if we want, out of goodwill, then we can give you something just to say thank you?
Mediation is a professional service,
okay,
like any other, like a doctor. In some countries, there is what we call a remuneration order, a guideline that shows you how to charge your fee. Especially in Kenya, mediators are, if they are doing court cases, they are paid by the courts, a fee. But private mediators, they charge a fee. It could be a percentage of the subject matter of the dispute. You can be paid per hour, and then also you can also be paid a flat rate. But the fees must be agreed before the mediation session. It should not depend on the outcome of the process, because that will be unethical. So you don't proceed with mediation if you have not agreed with the fee, and then you have to be paid a substantial portion of your fee before you continue with mediation. This is the practice everywhere, in Canada, in America, in Kenya, in other countries. I don't know what happens here about the fee regulations, but it's a profession. It's not a free service. But the other thing you need to do, you can as well. I did so many mediations free. We call pro bono. Especially if you are new and you want to get experience, you can do cases pro bono. I've also done issues to do with family matters, where the family is in turmoil. You help them, you reconcile them, they are happy, and that you get a satisfaction even without being paid. You can walk home tall, knowing that you have assisted people to live in peace. So it's not specifically for money only. It's there if you can assist people to create peace. I think that is more than money for those people who have not tested it.
But ultimately it's cheaper than the litigation process.
Extremely cheaper, because a case can take you 2 years, 3 years in court, whereas a mediation can take you 4 hours. I can give you an example if there is time.
There is.
I trained a student at Kenya School of Law in mediation and certified them as professional mediator. They went to their father's law firm in town, a father who has been practicing law for the last 40 years. They went to the registry and picked the case, a land case that had stayed there for almost 11 years. He asked the father, can you request the other parties, if they can agree, I can do the mediation pro bono. And the other parties say, well, we have nothing to lose. This case has been in court for 11 years. If the process you want to take us through is without prejudice, we are ready to come for it. They stayed for 1 week at Serena Hotel in Nairobi, and the matter was resolved. 1 week. People were coming out of a mediation shedding tears. They were relatives fighting over 11 years they had not used a piece of land. And then, the attitude that these people have, especially us as lawyers, when this young man went back to his father and told him, I've resolved the case, the father complained and said, you solve a matter in 1 week. Do you know that this is a matter that has educated your brothers and sisters? What are we going to eat? This is the kind of... This is the information I want to pass to all lawyers.
Yes.
I've told that also in Kenya. Most parts of the world, law firms have got mediation departments. People can select to go for litigation. They can select to go for mediation. You have nothing to lose. And from the statistics that I have, most people who have mediation departments, most law firms that have mediation departments are making more money there because cases are resolved faster and quickly. Okay. And the clients love it when their issues are resolved quickly. Businessmen don't have time to go to court.
Right. Okay. Yeah. So, provided it's free of prejudice.
Yes.
As we wrap this up, as we come to a close, Mr. Vincent, what are your last remarks?
One is we want to continue requesting all the advocates in the country to take it up and sensitize their clients, because those are the first people that approach them. As court, we will do our part, but we meet these people at a later stage. As court, we will also continue going into the communities to talk about mediation, to talk about ADRs, to talk about all this. But we request that this is also a combined effort. We cannot do it alone as judiciary because of the financial constraints and the time. So we encourage even you, the press, to give us some airtime, to encourage the people to know, to pass on these messages. We have a lot of messages that we can pass, but sometimes we cannot be able to do it on our own.
Right.
We would like the concerted efforts of everyone in this community, or every stakeholder has a stake, because when we don't resolve these matters, our lives are at stake, our communities are at stake, and the country is at turmoil. So the more we engage, the more we sensitize, we shall have peaceful communities.
All right, thank you so much, Mr. Vincent. Mr. Magerere, your last remarks.
My last remarks are that I've been a lawyer for more than 20 years, practicing law in the High Court of Nairobi and in many other places. I can tell you that for the 18 years that I've done mediation, I've changed people's lives. Mediation is the way to go. For those ones who are Christians, the Bible says, my people perish because of lack of knowledge.
Right.
We don't get what we want in court. We should be focusing, because it's very clear that when people are in conflict, there are three issues that are important. One, emotional issues, pseudo-substantive issues, and substantive issues. We focus, most of our conflicts have got emotional issues. Let us focus on mediation and we'll change people's lives and we'll live in harmony. Thank you very much.
Thank you very, very much. That was such a pertinent conversation. We'll share this on YouTube. Please tell a friend to tell a friend. Let's help each other. We all know that cases to do with, the litigation process, like he said, very draining emotionally and also financially. How about we embrace mediation? All right. Thank you so much, Mr. James Magerere, the President, Mediation Institute of East Africa and ADR expert across the region. Thank you so much for making time.
Welcome.
And also Mr. Vincent Emi Mugabo, thank you so much. He is the Registrar Supreme Court at the Judiciary right here in Uganda. Thank you so much. So that's it for Kickstarter. We'll be taking a short commercial break. We'll be back with so much more. Don't move a muscle.
You're watching Morning at NTV.